Welcome to the Justice Journal podcast. I'm Sacramento County District Attorney Anne Marie Schubert. I hope you enjoy this podcast series where we discuss important public safety issues and provide insight into who we are as an office and what we do both in the courtroom and in the community to provide the highest level of public safety through prosecution, prevention, and innovation.
Hello, everyone, and welcome to the Justice Journal podcast. I am your host, Rochelle Beardsley. Today's episode is a part of a series of podcasts focusing on the success our local criminal justice system has had in holding jury trials in an age of a pandemic. We're going to discuss 3 specific cases today. These were all completed by jury trial with the prosecutors who handled them. Our guests today are Sacramento County Principal Criminal Attorney Nancy Cochrane. Welcome.
Thank you.
Deputy District Attorney Kristen Andersen. Good morning.
Morning.
And Deputy District Attorney Ryan Roebuck.
Good morning.
Welcome, everyone. Why don't we start by having each of you introduce yourself? We'll start with Ms. Cochrane and tell us how long you've been with the office and what unit you're currently working in.
Sure. I've been with the office now for almost 25 years, and I have been involved in many of the different units, but currently I am working in the child abuse unit, and I've been here for approximately 11 years. We prosecute all crimes against children under the age of 14 in our unit, and we prosecute physical abuse as well as sexual abuse.
Thank you.
Hi,
Ms.
guys.
Andersen?
I'm Kristen Andersen. I've been in the district attorney's office about 13 years. I've worked like Nancy, but not as extensively in a lot of different units in our office. And actually during the pandemic is when I was moved over to the homicide unit. So I've only been in the homicide unit about 4 or 5 months.
Great. Mr. Roebuck.
Thank you. So I've been with the office just over 3 years, and I'm currently on Felony Trial Team 2, where we handle basically just general felonies of all sorts.
Great. Well, welcome, everyone. Thank you very much for joining us. So before we get into your specific cases, I want to provide our listeners with an overview of what the criminal justice, the trial procedure was pre-COVID-19. So prior to COVID-19, cases were assigned out of one courtroom. We refer to it as our master calendar, and that in Sacramento County is Department 9 in the courthouse. On any given day, about maybe 100 plus attorneys, folks would cram themselves into Department 9 to wait and see if they could get assigned out to trial. We would just show up. We didn't know if we were going to get a courtroom or if there was going to be a defense request to continue. We just showed up. We didn't know if we were going to get out to trial, but that's what the process was. Prior to COVID-19, we did not social distance. So during jury selection, we would cram about 60, sometimes upwards of 80 to 100 prospective jurors into one courtroom to do the process of jury selection, which also took a couple of days sometimes. We didn't wear masks at all at any time during the trial, and we could see each other's faces, which is important when you're selecting a jury, when you're eliciting testimony, when you're providing an opening statement or a closing argument. So we could see everybody, witnesses, lawyers, jurors. Courtrooms were also open to the public. Anyone could enter the courthouse at any given time, walk into any courtroom that was having a proceeding and sit down and observe. And that was part of the process. So things obviously changed a great deal post-COVID, and we're going to start talking about that. So I think the 3 of you would probably agree that things have changed drastically since the courts initially shut down in March of this year. We in fact didn't start doing or conducting jury trials again until probably the middle of June, if I'm correct. So I want to start focusing on our differences, on the differences during our discussion, but why don't we first start by having you guys talk a little bit about the facts of your case so that we can lay the groundwork.
Want to go first, Nancy?
So,
Sure.
So we're going to have Ms. Cochrane talk a little bit about her child abuse case.
Okay. The case that I prosecuted in June of 2020 was a case against the defendant Fong Mua. Mr. Mua was a former Alameda County Sheriff's deputy who had been investigated in 2004 for molesting a female child in his family, as well as domestic violence. He was investigated by the Alameda County Sheriff's Department. He was placed on leave and was not rehired after that investigation was over. Unfortunately, there was, at that time, there was no consequence to Mr. Mua for any of the alleged crimes that were committed against that family member. As we fast forward to Sacramento County, Mr. Mua was accused of sexually molesting 6 members of his immediate family. 4 of those victims were now adults and 2 were minor children. The adult victims came forward because one of the minor children had reported to them that they had been touched by Mr. Mua. An investigation by the Sacramento Police Department ensued, and ultimately Mr. Mua was arrested and charged with multiple counts of molesting not only the 2 minor children, but also the 4 victims who were now adults. That obviously went to trial, and Mr. Mua was convicted of 12 counts of child sexual assault by jury.
Thank you for that. Let's go to Ms. Andersen, who is going to talk to us about her attempted murder of a police officer case.
Thank you, Rochelle. I did mine, it started, I believe, the first week of July 2020. My case was about 3 years old. It had taken quite some time to get through the criminal process. So my victim and his family had waited 3 years to get to jury trials. So although it looked very different during the pandemic, they were very happy to start the process. So essentially 3 years ago, in June of 2017, Deputy Ladwig, who had worked for the Sheriff's Department for about 3 or 4 years at the time, was on his normal routine patrol at the light rail station at Interstate 80 and Watt Avenue. At that time, he encountered the defendant, Nakori Span. Nakori Span was extremely angry that day. He was yelling at the police officer. He was attempting to contact other civilians who were there. So it wasn't initially just directed at the deputy. When Deputy Ladwig attempted to find out what his purpose was for being at the station, whether he had a ticket or not, Nakori Span failed to give him a valid ticket, which was required at that particular station at the time. At that point, Nakori Span lunged at Deputy Ladwig and attempted to punch him in the face. Within seconds, unfortunately for Deputy Ladwig, Nakori Span was able to gain control of the deputy's firearm and within a minute had fired the gun twice at close range at the deputy's face. He actually struck the deputy one time at close range in the side of the face, and luckily for the deputy, he missed the second time. After that happened, luckily for Deputy Ladwig, a civilian, actually, Good Samaritan, jumped off the light rail and came to the deputy's aid, which was amazing. And I think his testimony at trial was extremely moving. And I think the jury was also swayed by a lot of what he talked about. But anyways, Nakori Span, after he shot the deputy in the face, ran to a neighboring hotel at the Red Roof Inn, where he barricaded himself inside the hotel on one of the hotel walkways for approximately 3.5 hours. The Sheriff's Department responded, and after about 3.5 hours, they were able to secure him safely, where he was then arrested and taken into custody. And then we waited for the 3 years to get to trial. Deputy Ladwig spent 11 days in the hospital. He endured hundreds of doctor's appointments. 20 plus surgeries, and amazingly was able to make almost a full recovery. And so by the time he was testifying 3 years later, he was able to speak very well on the stand and was actually testifying for a little over a day and could do it very well. So luckily for him, he's made a full recovery. The jury did convict Nakori Span of multiple charges, attempted murder on a police officer with the use of the firearm, which caused great bodily injury to the deputy, and then just assault on a police officer. And then he later went on to be sentenced to 32 years to life.
All right, thank you for that. Let's move to Mr. Roebuck's case. You're going to be talking to us about a felony burglary, is that right?
Yes, Rochelle. So my case took place back in October of 2018. Two elderly victims, Mr. and Mrs. Roebuck, both in their mid-70s, were asleep in their home. They went to bed around midnight on the night of October 1st. They woke up the next morning to find that the downstairs of their home had actually been burglarized while they were asleep. They immediately contacted the Sacramento Sheriff's Department, who sent crime scene investigators out to their home. And as they started to inventory, they realized approximately $20,000 in various items had been taken. This included a number of jewelry items, including a family heirloom of Mrs. Roebuck, which was actually her diamond wedding ring that her mother had given her. That was the mother's ring as well. In addition to that, there were cash, a number of jewelry items, and particularly of interest in that case was two cell phones that were actually taken from an office in the downstairs of their home. They also noticed that a window above a desk in the office was open that they remembered closing the night before, as well as the door that led to the backyard from that office. So once CSI came out, they actually were able to lift latent fingerprints from the window that was above the desk. On that window, there were fingerprints both on the outside and just on the inside of the window frame itself. CSI collected those prints and then submitted them to the Sheriff's Department for ID. In these particular instances, those fingerprints were sent to the fingerprint identification specialist, but they weren't actually run until the summer of 2019. So essentially the case went cold in terms of leads for just under a year. When fingerprint specialists ran those latent prints, they matched a suspect, Donald Mayberry. That suspect was later arrested. Mr. Mayberry was brought to trial. He faced both first-degree residential burglary charge as well as an enhancement for both victims being present in the home during the time of the robbery, as well as a prior strike allegation. What ended up being the key piece of evidence in the case was that after Mr. Mayberry was arrested in 2019, a pawn search had been run on him, and he actually was found to have pawned one of the two cell phones at a what's called an eco ATM, which is essentially an ATM type of machine that collects electronic devices at a mall. And so we were able to match him pawning one of the two cell phones that were taken from the residence in addition to those fingerprints. He was convicted ultimately of the crime of burglary, as well as the jury found his prior strike true, and then he was ultimately sentenced to 17 years in state prison.
Thank you all for those summaries. They're obviously very serious cases that you were all able to successfully prosecute during the age of COVID. I want to go back again to Ms. Cochrane. Let's take a deeper dive into the differences that you observed or had to undergo because you did get out to trial during this pandemic. Can you take us through the pretrial process, which includes the TRCs, the trial, which is the Trial Readiness Conference, and up to the case actually getting assigned out to trial, please?
Yes. In this particular case, Mr. Mua was very anxious to have his jury trial. He was arraigned in October of 2019. The preliminary hearing was almost immediately set. And from there, we had a number of preliminary hearing dates, as well as a couple resets for trial dates. Eventually, the trial was set for March 26th of 2020. During that time, there were issues that were beginning to happen because of the COVID pandemic. Eventually, on March 20th, prior to Mr. Mua actually getting out to trial, the courts closed. And actually on March 23rd, all trials had been suspended. So Mr. Mua's trial was then put basically in a queue and had some priority based on the fact that we were ready to go to trial before the courts were closed down. On June 15th, jury trials resumed in Sacramento County. And that was when we started the process of being assigned out for trial. So generally the trial readiness conference procedure is that we have a hearing with the defense and with what we call our home court judge to discuss whether or not the trial is ready to proceed, whether both sides are prepared. And we were able to do that. Things were being done via Zoom. And so things were a little bit obviously different in that sense. As you said earlier, we were not meeting face to face any longer. Generally, we would meet in court, discuss the case with our judge, talk about the length of the trial and any issues that might be coming up in terms of whether how long we should be assigned out for, and those kinds of issues. So ultimately, trials resumed because Mr. Mua's case was more on the priority track because we had been set for trial. We were actually assigned out to trial on June 17th. And so that process, it happened, the TRC process, the Trial Readiness Conference process, proceeded basically as it normally would, but for being held on Zoom. Once we were assigned out to trial, then there were different issues that came up in terms of how to proceed with jury selection, how we would meet with the court, because prior to starting jury selection, you meet with your trial judge, you discuss issues, you exchange briefs. All of that was done electronically. So the defense and myself, we were exchanging briefs and witness lists electronically. We were both sending these items to the court electronically. There was a lot of communication with the defense, the court, and myself via email. And then there was a set time when we did meet in person with the court. And of course, we followed all of the COVID procedures that the courthouse had put into place. But at that point, we had been assigned to trial, and we did process how jury selection would happen, and what steps the court administration had put into place to make sure that all parties, as well as prospective jurors and the court staff, remain safe during the pandemic.
Thank you for that. So pre-COVID, we talked about the process, and that would include showing up to the master calendar court, which was Department 9 in the courthouse, and calling ready for trial and waiting to see if there was a courtroom available, right? And sometimes the court had the option of trailing your case another 10 calendar or 10 court days, right?
Yes, that's correct.
So how was your trial assignment process different than it was pre-COVID?
Right, good point. Because pre-COVID, we would have a trial assignment calendar out of Department 9 in the main courthouse. And as you previously mentioned, we could have 80 people in that courtroom defense attorneys, spectators, out of custody defendants, court staff. And we would have previously checked in on an electronic system to let the courts know whether or not both sides were ready. And if both sides were ready, we would proceed to this trial calendar with the hope and the expectation that we would be assigned out to a trial court. But as you mentioned, we would go to the trial assignment calendar, and oftentimes we would just sit and wait for to find out which courtrooms might be available, which courtrooms could take a trial of just a couple days or a few weeks, or perhaps even longer than that. And oftentimes, even if both sides were ready to go to trial, if there were no additional courtrooms available, as you said, the court would ask us to come back in a day or two to find out whether or not there was another courtroom available. Once the pandemic started and the courts were doing everything by way of either Zoom or electronics, then we would do this basically the same thing. We would determine whether or not we were ready to proceed. We would be in communication with the court staff who was responsible for letting the assignment judge know. And then we would wait to see whether or not we had been given a courtroom. And all of that was done electronically. So there was a lot of communication between the defense attorneys, our office, and the court administration in trying to determine which cases would be assigned out to trial and when they would be assigned out to trial.
Yeah. Big difference. Thank you. Let's talk through the jury selection process now. And I want to go to you, Ms. Andersen. Can you walk us through the differences in your jury selection process for your trial?
Well, pretty much it looks completely different, other than the fact that some of our jurors are in the courtroom with the DA. So let me back up a little bit. Before the pandemic, jury selection was myself, judge, court staff, defense attorney, defendant, and then anywhere from 80 or 60 jurors in any given courtroom. I mean, you're literally packed into the courtroom next to each other. Then we pull up what we call the 6-pack, which is 18 people. We put 12 people in the jury selection box, and then we sit 6 people in front. And then the judge goes through a pretty basic questionnaire. It was 1 page generally, unless you were involved in some sort of life sentence case or a homicide. And then sometimes it was a little bit more extensive. We go about our questioning. And then when it gets to the point after myself and the defense attorney has asked questions to the prospective 18 people in what we call the box, we would exercise peremptory challenges where we would kick people for a number of reasons. They would leave, and then we would pull someone from the audience, one of the 60 people waiting, into the box. Well, the pandemic hit and everything looks completely different. And I think Nancy's case was one of the first ones to go. So her jury selection may have looked a little bit different than mine. I know it has continued to improve, and the courts, our office, and the public defender's office, I believe, have gotten a lot more efficient, and we've been able to kind of make it a little bit quicker, because obviously since the pandemic, things are taking a lot longer. So essentially our office got together with the panel and the public defender's office and the court and came up with about a 25-page questionnaire. And not all judges in the courthouse right now are using the questionnaire, but we did use the questionnaire in my case based on the fact that a law enforcement personnel was the victim and some of the issues that were going on socially. And also because of COVID, obviously people who prior to the pandemic had got jury selection or jury duty would come, and you were only excused if you had a hardship essentially, or you weren't being paid for being there, or you had a prepaid vacation, things of that nature. Well, now with the pandemic, obviously people had a lot of health concerns. People were concerned about touching, the elevators or being in close contact with people. So our questionnaire was extremely extensive. It covered a lot of areas, including, do you have concerns about COVID or other health concerns that may cause you to not be essentially fit or suitable to be on that particular panel. So in my case, we used the questionnaire. So that made my jury selection go a little bit longer, but I believe it was more efficient overall. So essentially what happened during the pandemic is we called up, in my particular case, I think about 150 jurors. And at the time that my case was going on, you could only do jury selection on one floor of the courthouse. So there was only one case picking a jury at any one time, just because of social distancing concerns. You know, they had chairs marked off in the hallways so that people weren't sitting next to each other. And in the courtroom where myself, the defense attorney, and the judge were, and the defendant, so the main courtroom, I'll call it, we could only have 16 prospective jurors at any given time. So think about how different that looks. So I'm questioning a box full of only 4 people, which is what it looked like when my case went to trial. There were only 4 people sitting in my jury box, and the rest were in the back of the courtroom, which presented all sorts of challenges. But for jury selection, it was extremely tough. So we had about 20 people total, including myself and the other parties, in my main courtroom. And then we had 3 other courtrooms that we had linked in through Zoom. So the technology actually, I think, worked really well, but it took some getting used to for everybody. And so the judge would go about his questioning. He'd speak directly to the people in the main courtroom, my courtroom, and then there'd be 3 remote courtrooms that were listening and following along. So the challenge came really when we started getting to the peremptory challenges, because you were kicking people who were in the box but were seated behind you. So, you know, as most good district attorneys know, I mean, part of kicking someone is you're able to connect with your jurors, you're watching their mannerisms, you're speaking directly to them. It was very strange to be kicking people sometimes who were behind you, or you weren't looking directly at all of the time because you were trying to also pay attention to the camera because you're speaking to courtrooms that are remote. So once you kicked, let's say we got down to 11 people in the box, and so you have to have 12. So we had already exercised our peremptory challenges. Well, we needed to then fill in that 12th spot and bring in a couple more jurors to our courtroom to get to the 16. Well, the difficulty was if we only brought in 4 or 5 jurors every time, it was going to be extremely slow. So what my judge decided to do was take the 11 people who were in the box and put them in another courtroom and bring in 16 people. Well, the strange part about that is then you're kicking people from your box who are not even in your courtroom. So you actually have to keep really good notes about who is seated in your prospective juror panel in your box, people who could be on your jury. So there were all sorts of challenges. I think we got it done. I think my judge did a great job, but it just took a little bit longer. Although at the end of the day, I think justice was served and our jury was able to work efficiently and effectively. So despite all of the COVID challenges, and although it looked a lot differently, we were able to get to the same end result. But I would say the major difficulty for jury selection was not only not having enough people in the courtroom at any given time, but also the fact that jurors were wearing masks. I mean, the parties are wearing masks the entirety of the time. So when you're questioning them and you're speaking to someone in the very back of the courtroom and not in the jury box like normal, you can't hear them. And it's hard to gauge someone's emotion and their expressions when their face is covered by a mask. So you have to learn to pay attention to other things and, you know, essentially improvise in a lot of ways so that you can make sure you get 12 people who are willing to work together. But yeah, it was definitely a challenge.
So let's move on to the presentation of evidence in the people's case. Mr. Roebuck, how did that go for you?
Well, so I would just piggyback on something Ms. Andersen said, which is that I've done a couple trials now during COVID, and each judge I've found is doing it slightly differently. So I think that's important to keep in mind. The basic premise of all we talked about is the same, but each judge kind of goes about their individual courtroom and their rules differently, as it was before the pandemic. But I can say that doing evidence or putting on evidence was very different than anything I had ever experienced. First, obviously, it's the spacing that Ms. Andersen mentioned as well. You're putting on evidence, but you literally have your back to jurors, whereas that normally would be maybe an audience member or someone from your office or a victim sitting there. You have to be very cognizant of where you're sitting. I'm a big guy, and even just sitting in my seat, not moving, I had a juror ask a question if I could move because she couldn't see some of the technology because of where she was seated in a taped off designated spot. So I think being cognizant of that, we were also restricted in both of my cases to doing your examinations, for instance, while seated. It's not something that I do normally. So it was very different to kind of force myself to stay seated and be engaging with my witness as well. So I think that was kind of a challenge learning that. That also came into play later on when you're arguing, both doing your opening and closing, because you again have to be cognizant of where your position is in the courtroom. The other thing that we had is they've moved the projector in the courtroom to essentially be behind or just to the side of your actual witness. So it was just a completely different courtroom setup than what we're normally used to, as well as making sure that the people in the audience who are your jurors can actually see what you've projected on an overhead and that kind of thing. I'd also say what was different is we were required, or I was in both of my trials, to essentially have duplicates of all of my evidence. So I had to have basically my evidence in 3 separate forms, which was sort of different. I had to have sort of permanent paper copies or discs that were marked by a clerk that were going to be preserved in the file. I had to create an exhibit binder with tabs for each exhibit and keep track of which witness would look at each tab and direct those witnesses to that tab. That binder stayed on the witness stand. And then I had to have a third set of all of those exhibits on a thumb drive electronically so that I wasn't approaching the witness stand to basically do witness or evidence walks and things of that nature. We had to do that sort of at a distance with me doing it remotely on the projector and the witness looking at a binder. So that was really different than what we've normally had to deal with. I'd also say that the pace of my trial, I don't know about the 2 other attorneys, but my trial went extremely slow. And a lot of that had to do with the fact that there were a ton of breaks for technology issues that threw off the pace. I think it made the jury sort of be a little bit more tired and anxious to leave and that kind of thing, because they kept having to have these extended breaks to fix projectors, fix microphones. All of that, I think, played a role. And then I guess just 2 other things that were different. I had elderly witnesses. My victims were both in their 70s. And as we all know, that was a particular concern for public health, right? To bring down these people in their 70s, have them come in during a pandemic and have to be in the courthouse around other people, not at home quarantining, and sort of getting a judge to accept that and be willing to be flexible with those people so they weren't waiting, for instance, all day in the hallway was something new. And then lastly, argument was different. I know some judges I've heard allow attorneys to take off their masks during argument, but I was not allowed to do that in either of my 2 cases. And trying to be persuasive when you're literally covering your face and all your facial expressions and your voice is muffled and you're trying to talk to people who are sitting basically in the back row in the audience that are your jurors was a significant challenge compared to how we used to do trials. So those are just a few of the things.
So back in the good old times, pre-COVID, you would have a box of 12 jurors plus 2 or 3 more alternates, but they'd all be in the jury box and you could stand in the well and you could argue your case. Were you made to sit down when you argued, the 3 of you, or could you stand up and move about the courtroom with your mask on?
I was given a very small area in the well behind the podium so that it sort of restricted my movement.
I asked both of my judges if I could stand basically in front of the counsel table and just remain standing in that one area. I did not move around. And part of the concern as well was the court reporter, because the court reporter is so close to us. And so everything had to be sort of measured and marked out so that everyone felt comfortable with where I was standing. And I agree with Ryan that I gave my closing argument with the mask on, and it was very, very different than anything that I had ever done pre-COVID.
I want to follow up as well as about the exhibits. So before COVID, let's say we wanted to introduce a photograph of something, right? We could take the photograph to court, walk to the witness stand, show it to the witness, and then come back to counsel table and put it on the projector that the jury box was basically in front of, right? So now we have the different forms where a witness, you would put the photograph in a what you call an exhibit binder. Is that right?
Yes.
And then how would you begin to ask questions about that and show it to all the jurors? Was that via projection?
Yeah, so
Essentially, for me, that's how I did it. I mean, essentially, I would, ask foundation questions, ask the witness to turn to tab 2 in the binder, authenticate it, and then if they did that, I would project it on the projector with the electronic exhibits that I had on a thumb drive.
the only thing that became a little bit difficult with is when you had like a video, let's say. I had a lot of videos in my case, and so the witness is seated on the stand, but the projector is directly behind them. So having them kind of scoot over and have to turn around to look at the video was challenging. I had multiple different videos in my case. So with a photograph, it works okay to kind of look at the binder, authenticate it, and then show it to everyone because they have a copy in front of them. But with the videos, it became a little bit more challenging. We were able to do it in a way that was efficient, but I think it's difficult. Or if you have a police officer or witness who needs to look at a map, even if you have a copy of the map in front of you, what if they need to draw on it? You know, let's say they want to give the location or the area that a vehicle drove, or you know, which way the suspect vehicle took off from the complex or something like that. Normally we'd give them a marker, have them draw it, and then we'd put it on the visualizer to show it to everyone. So we've definitely had to be creative in the way we're doing things. And I think the courts have worked really well with us trying to figure out a solution in a way that works for everyone.
Yeah, and I would just add to that. I agree with Kristen there with the especially videos of interviews being projected behind the detective while they're on the stand. It made it a little awkward, but we managed to get through that all right. But what I wanted to mention that this exhibit binder that was on the stand, after each witness left the stand, both of my courtrooms cleaned that witness stand, and they also cleaned the exhibit binder because someone else was coming in who would probably be looking at some of those exhibits, as well as they always had gloves available if the witness felt more comfortable wearing gloves while looking at the binder.
That's adding a lot of time, I guess, to the presentation of evidence. I see that. Okay. I want to talk about how eliciting victim and witness testimony also changed. And I want to kick back to our resident expert in the area of prosecuting child abuse cases, Ms. Cochrane. Yours are heavy victim cases that required testimony sometimes from young people during this time. How was that different?
Well, it was, I guess in some way, maybe you could say that for especially young kids, they didn't know the difference. So this is kind of their new normal, wearing a mask, going someplace, being able to take the mask off. But I will say that in both of the cases that I've done during the pandemic, both of them multiple victim cases. The one that I talked about earlier had 6 victims. The second one had 5 victims. And so there is oftentimes a lot of reassuring that has to take place prior to them coming to court. especially if you have moms, dads, the caregivers. I'm not sure I want to come. I'm not sure I want my child to come. How can you assure me that everything is going to be safe? And so there was a lot of preparation time that was spent explaining the courthouse procedure as well as the courtroom procedure. And the Sheriff's Department, I think, has done a good job. They've set up a station in front of the doors of the courthouse. Everyone has to have their temperature taken before entering. There are sanitizing stations everywhere. As you mentioned earlier, chairs are blocked off to maintain social distancing if anyone sits in the audience or in the hallways, excuse me. And then as far as the public watching the trial, there were a couple seats that were available. And oftentimes those would go to a lottery system that was taken care of by the court administration. But making sure that parents and caregivers were comfortable coming to trial and they themselves testifying, but assuring them that their children would also be safe. So there was quite a bit of time taken in that preparation. And then as Ryan said earlier, and Kristen also, the jurors are spread out all over your courtroom. There are only a few in the jury box. Most of them are seated in the audience. So especially when I had younger children coming to court, they would walk in with their little mask on. They would take the stand. And the way that the courtrooms have been set up, that the judge is surrounded by plexiglass. And then also on the witness stand, the witnesses are also protected by plexiglass. Both of my judges allowed witnesses to remove their masks while they testified. I kept my mask on, but they were allowed to take theirs off. And both judges had a little spiel that they would give each witness, and especially with the kids, you know, like, oh, I see you came with your mask today and I'm gonna let you take it off now. And both judges very mindful of these young children and this already traumatic situation that they were going through, but then add on to it the plexiglass, the masks, and things like that. Luckily, other than the masks and the plexiglass and the jurors seated throughout the courtroom, the testimony itself and me wearing a mask, the testimony of my victims themselves was very similar to what it would be, I thought, pre-COVID. Of course, some variations, but once people felt comfortable coming into the courtroom, they seemed to do just fine. Interesting.
Well, thank you all for your insight. I heard about a lot of adaptation and challenges, and kudos to all three of you for being able to successfully prosecute your cases during this time. I want to ask about silver linings. Okay, I know that we've talked about challenges, right? So what changes did you find beneficial or more efficient in your cases? I'm going to open that up to the panel.
The whole process just kind of bonded my family together. One of the things that Nancy mentioned is there's only, one, maybe two seats for the prosecution and one seat for the defense and then one for the press. So usually you have a victim testifying, they can have a loved one in court with them and or a victim advocate. So normally we would have entire families in the courtroom. They're kind of all able to watch the process. Since COVID, they now Zoom in to one of our conference rooms. And so I had a lot of family on my case, as you can imagine. And I think despite the challenge of not being able to be in the courtroom, that kind of all bonded together. They would come here, they would, take their breaks together. They were a very close-knit family, and they were able to bond a lot with my victim advocate, because the victim advocate would also stay back at our office and spend, the whole day with them in the conference room. And so I think despite the fact that they couldn't be over in court, they were still able to, through the means that our office took to make sure that they could be a part of the process, they were still able to participate and show their support for the victims. So it was nice to kind of see the coming together of the families that I had in my case. So I think despite the difficulties, the silver lining would just be that they were still able to support their loved one and kind of come together through the process.
Yeah,
Thank you.
I would definitely agree with Kristen on that. I think it bonded people. And I think the silver lining for me was that I saw that our process still works. And it works even when we're faced with a horrible, horrible disease that people are afraid of, that justice is still being served. Our victims are still being able to have their day in court. Defendants are still getting fair trials, even with these adaptations that are occurring because of the pandemic. And it has just made me feel even prouder of the fact that we have a system that works, that the defense bar has been willing to participate in this as well, and that the courts have really gone out of their way to make people feel safe. And I'm just so happy that it proves how strong our system can be and that our system does work.
Thank you. Mr. Roebuck, silver lining?
Yeah, I mean, I completely agree with what Nancy and Kristen said in terms of their observations. I guess from a practical standpoint or a procedural standpoint, I think that this pandemic has forced our court system, our office, the defense bar to look deeply at how we go about the trial assignment process. And it was a little bit of, learning pains or growing pains as we went along to try to kind of figure out a process. But coming from a volume unit where we have a ton of cases, that old system of just showing up to court every morning in Department 9, never really knowing if you're going to get assigned to trial, having to use that trail period to maybe call ready on a case today, but have to be ready on a different case the following Monday morning, was a constant sense of sort of anxiety and shuffling. And I think that the way that we're doing it now, where it's much more refined with a check-in process, what courtroom you're going to go to a few days ahead of time, if you're going to be assigned out within a few days ahead of time. All of those things, I think, have given us much more certainty. It's helped us communicate with our victims and our witnesses better in terms of giving them more solid timelines and not keeping them sort of in the dark about, hey, you might be needed tomorrow, it might be next week, it depends if we get trailed. We have a much better understanding of that now. And I think that, practically speaking, has been a pretty big silver lining for us.
Great. Sacramento County has been basically a trailblazer for conducting jury trials during this time. The numbers as of the date of this recording are about 70 jury trials that have been completed since the court opened back up in June of 2015. And folks can look it up, but that is head and shoulders above what any other county is doing. And I think that most of it is because of folks like you who are consummate professionals who rather quickly had to adapt to these very different scenarios and situations. So kudos again to the three of you. Thank you very much for sitting with us today and having our listeners take a peek into the courtroom during the COVID pandemic. And thank you for serving justice for the victims in your cases, even during COVID-19. Congratulations.
Thank you for listening, and I hope you enjoyed this episode. You can find all of the Justice Journal podcasts on our website at sacda.org, iTunes, Google Play, and YouTube.